Welcome to the third episode of Call to the Bar, International Law Over Drinks, a series of casual conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, and this evening I'm joined by Associate Professor Ntina Tzouvala of the Australian National University College of Law, everyone's favourite Marxist subversive and author of the groundbreaking Capitalism as Civilization, a History of International Law. Ntina, good evening. First question, what's your drink?
Hi, Douglas. Thanks for having me on board. It will sound extremely pretentious. I am having, basically at the end of the day, flavored fizzy water, flavored with blood orange, but it's the sort of fancy flavored fizzy water that the can calls itself an infusion and claims to have some sort of probiotic qualities. So there you go.
Right, very
What are
helpful.
you?
Yeah. Oh no, what am I drinking? Yes,
Yeah.
so we're meeting a little earlier than we'd planned, so I don't have a glass of anything harder to hand. I'm still making my way, as last episode, through a sampler box of South Korean teas, and this evening I am drinking a hydrangea tea, hydrangea being a flower I associate with a lot of Australian front yards. Never had it as a tea. Smells a little bit burnt, but actually has a very pleasant kind of mildly fruity taste.
We're both drinking something I think sufficiently hipsterish and like
Yeah,
esoteric.
no, absolutely. All right, so I like to begin each of these shows with a little bit of background on our friendships and career paths. So to the best of my recollection, we first met at the Australian-New Zealand Society of International Law annual meeting in July 2019. Would you like to tell your version of how we became friends?
Yeah, I think your version sounds true, but I think obviously the necessary background to that is the strange friendships and sense of familiarity we develop with people on Twitter, right? So I think we both felt like we kind of knew each other a little bit before we met as part of the international law Twitter and the especially Australian-based international law Twitter. And I think, of course, because then a year later in July 2020, I moved to Canberra. I would say at that stage we became proper IRL, as they say, friends.
Yes, then there was that period where it was rather difficult to leave Canberra during COVID when borders would be randomly closed. So for those listening not in Australia, we had a kind of unique COVID response where the different bits of our federation suddenly decided that internal borders were a thing again, and Canberra in the Australian Capital Territory became a fairly small island in the middle of New South Wales. Now, for early career listeners, or just the curious, could you talk a little bit about how you got into international law and the career path that's brought you to your present job?
Right, of course, thanks. So in my undergrad, I wasn't a particularly good student, or rather, I was good in terms of I was getting good grades, but I was a total sort of student that I would now hate. I would never turn up in class. When I did, I would argue from first political principles rather than from any familiarity with the prescribed readings. And I was mostly spending my time doing student activism in Athens Law School. And if I was into any sort of law, it was more Greek constitutional law, partly because Greece has had such a turbulent political history that in a sense this felt like a very politically engaged and engaging subject. However, when I finished my undergrad, I decided to do a master's, mostly because it was kind of the done thing. And the problem that I faced was that I wanted to do the master's in the UK, mostly for language reasons. But of course, the public law system is so different. So I ended up doing international law as my master's a little bit by accident. And as I was doing my master's, I actually discovered for the first time that there is something called critical legal theory, and especially Marxist legal theory. That was a fantastic discovery. So the choice of subject became a little bit random, or not random, but I ended up being an international lawyer because that seemed to be the area where I could do this sort of critical Marxian work that I was into. I call it studying, let alone working, let alone draw a salary. And I did my PhD in Durham, UK during the peak of the Greek financial crisis. And because of the peak of the Greek financial crisis, I was like, let's do a PhD, kind of seed out the crisis and see if I can go back after. Soon it became obvious that that was not going to happen. In 2015, I was really lucky that Professor Anne Orford at Melbourne Law School had just been awarded a laureate fellowship. For non-Australians who are listening, that's like a shit ton of money. That's what a laureate fellowship is. She was advertising for 2 postdocs, and I was really, really lucky that she offered me one. So I moved to Australia, and I don't know, Australia is a very easy place to live and a great place to work. And that's how I ended up still here.
Thank you for that very much. Yeah, I recall that moment around the Greek financial crisis, in that when I looked around law faculties, I started calling Greeks the new Australians, in that they were suddenly everywhere, but all in international law, which had been the reputation of Australians in UK law schools up to that point.
I'm now both Greek and Australian, so
Right.
like I'm really the quintessential international lawyer.
Right, you've found the center of the Venn diagram.
Right.
Okay, well, let's move on to our main topic this evening. So once again, we're going to be talking about events in Gaza, and it shouldn't need repeating, but as in episode 1, we consider as lawyers Hamas to be an organization that has committed war crimes and other grave violations of IHL. As I've said before, it doesn't matter how just you think your cause is, you are still bound by international law. And that obviously goes for Israel's conduct of the war as well. The law applies equally to both sides, or it is meaningless. Now, with that out of the way, one central focus for international lawyers has been proceedings at the International Court of Justice, particularly the case brought by South Africa against Israel under the Genocide Convention. So in episode 1, Dr. Juliet McIntyre spoke with us on the ICJ's ceasefire order in relation to Rafah. Now, Dina, your concerns this evening is something different. In particular, you're interested in the way that South Africa's legal team has approached the Genocide Convention in its written submissions and in the oral proceedings. Now, just again for context, it bears stressing that South Africa has standing here because of a dispute resolution clause in the Genocide Convention, which binds both it and Israel as state parties. That answers 2 of the questions that often get thrown at us as international lawyers. Why isn't South Africa also arguing this in terms of the law of armed conflict, or at least doing so expressly? And that's because the Geneva Conventions don't have such a dispute resolution clause. And why isn't it pursuing a case against Hamas? And the answer there is that Hamas isn't a state and therefore can't be a state party to the Genocide Convention. So when we do look at South Africa's ICJ submissions on the question of genocide, do you think there's anything there that you find distinctive legally or jurisprudentially?
Thanks. So, yes, I think a lot about South Africa's oral arguments in written submissions, and I do so for a reason that many pointed out very early. I think Andil Hack was one of the first people who mentioned that on Twitter, which is South Africa, I think, both for tactical reasons, but I also think for deep jurisprudential reasons, and I'll come to that, has focused less its submissions and arguments on the direct killing of Palestinians through bombings and guns, gruesome and terrible as it may be. And they have focused much, much more on another part of the Genocide Convention, or at least on another sub clause, which is the calculated destruction of conditions of living with the purpose of bringing about the destruction of the group in whole and in part as such. So their argument has been, you can see it literally in the number of pages or in the number of minutes that they devoted to this argument. They are arguing that things like starvation, of course, but also more broadly, the destruction of the food system in Gaza as such, regardless of aid, the destruction of homes. There's parts in Gaza where more than 50% of buildings have been destroyed. They're fully uninhabitable. the destruction of the healthcare system, but also destruction relevant to us of universities and other educational institutions, are not simply an unfortunate byproduct of a conflict, as Israel claims, but rather their sheer intensity, together with a number of statements by senior Israel officials, means that they are calculated to destroy Palestinians as Palestinians in Gaza. And as I said, there is a number, I think, of reasons why South Africa is doing this. I think and I'm speculating here, but if I was in the South African legal team, I would like to avoid getting very deep into the nitty-gritty of targeting questions, especially because at least the interpretation of Israel, of whom they can target directly, is quite unorthodox in international law, but also I think because IHL can be quite permissive in that regard. I think rather their argument, if they can also, of course, prove intent, helps them to go around questions of IHL. That's the first issue.
I mean, just to unpick a couple of issues there, I think, for the listener. So first, you're focusing, as you say, on the form of genocide that is inflicting conditions of life upon the group calculated to bring about its destruction in whole or in part. And that allows the South African legal team to say, hey, there's a bigger pattern here. Now, the archetypal form of genocide is the first form kind of laid out in the convention, killing members of the group. But I think this relates to something that you've often pointed out to me, is the very high threshold of proof that the ICJ applies to state responsibility cases on genocide. You might want to say something about that in a moment. But essentially, one of the options for Israel would have been to say, well, you can't say that we're killing members of the group genocidally. We are killing, people die in war all the time. And if you want to prove that we have deliberately targeted civilians or targeted military targets, but taken an inappropriate level of care, that we're not disproportionately harming civilians, then, as you say, you can get bogged down in the detail of humanitarian law very rapidly. And you have very fine-grained evidentiary analysis, kind of strike by strike by strike. What one scholar once referred to, and I've forgotten his or her name, but death by 1,000 proportionate strikes. That's
exactly right. And that's a problem many have pointed out about IHL, right? That it calculates proportionality based on each individual military operation and not as a whole. Right.
And accepts as a starting point that civilians can lawfully die.
Absolutely. They cannot be targeted, but they can be killed. Absolutely. And once you go into this discussion, especially given the sophistication of Israel's military apparatus, including the legal part of its military apparatus, and also, of course, the relative inexperience of the judges, or at least of many of the judges of the ICJ with IHL, which is a highly specialized field of law that has really its own laws, but also in many ways its own habits and ethics that, take, as you said, usually most IHL lawyers take for granted the ground, the legitimacy, or at least not illegitimacy of violence in war, right? And the fact that some civilians will die, perhaps millions of civilians will die potentially lawfully. I think even the most critical, not in the technical sense, IHL people have at least understand that this is how the field works, and in order to be legitimate participant, you cannot be a vocal pacifist, right?
Right.
I imagine that for South Africa's legal team, getting sidetracked into these discussions would lead into very difficult evidentiary questions, and they would lead to very complicated doctrinal IHL questions. And I would imagine that's something South Africa wants to avoid. And I think that's something South Africa wants to avoid because if you have followed, of course, I know you have, but if our listeners have followed the oral proceedings, that's clearly what Israel wants to do, right? It's very obvious that Israel's councils keep bringing back the discussion to international humanitarian law, which I think they rightly perceive as more permissive, more, I would say, argumentatively and culturally attuned to what they're doing. Right? Whereas I think if the conditions of life question raises the issue you just talked about, which is the cumulative and comprehensive harm brought about by this military campaign as a whole. And I think it is very hard for someone to argue that conditions of life right now anywhere in Gaza are conducive to human life. And I don't mean human flourishing, I mean human life, minimum survival in a context where there is no food, there is no water sanitation. Hospitals in Rafah are at 450% capacity, I read somewhere. And of course, no housing, right? So these, I think, is relatively easy to prove that are conditions that can bring, that are calculated to bring the destruction of the group as a whole. Of course, the question of intent is always in the background, right? And as you alluded to, the ICJ has adopted a particular interpretation of the Genocide Convention that I think is not necessary by the text of the Genocide Convention, that says they will only accept that there is genocidal intent if there is no other plausible interpretation of the acts that certain states or non-state groups have engaged in, right? So of course, this does not solve by itself the question of intent, but I do think it can sidestep the problems of IHL.
Right. Sorry, just for the Israeli side, in making their case, that question of intent is a way potentially of bringing IHL back in again, right? Because they can say you can't infer genocidal intent from this because, again, we claim everything we were doing is justified by international humanitarian law. In fact, you could even go one step further, not that any sane state would do this. You could actually, it would seem, defeat that finding of genocide by simply saying, actually, we confess that we were doing some totally different type of international crime.
Yes.
You could actually say, no, we lost control of all these rogue units and we accept that what was happening on the ground were war crimes, but there was no overarching intent, so there's no genocide. Oh, and look, this court doesn't have jurisdiction over war crimes.
Yes, that is absolutely possible, including even ethnic cleansing, right? Again, the court doesn't have jurisdiction over ethnic cleansing. Israel could admit to ethnic cleansing and the ICJ would have to not adjudicate the case.
Right. So again, just for listeners, I mean, ethnic cleansing isn't a term of legal art. It gets applied to different things. So some factual scenarios that we describe as ethnic cleansing might be part of a genocide, but in legal terms, it's probably most easily categorized as something like, the crime against humanity of persecution coupled with the forced displacement of civilians.
Displacement, absolutely, yes. So I do agree that this could happen. I don't think that it will happen, of course. But of course, then the question becomes a question of proving intent. I think there has been few cases in which intent has been not easier, perhaps, but less hard to prove. It will still be an uphill battle for the legal team of South Africa, but I think especially the question of rogue units would be hard to fully prove, especially given how South Africa, especially in the January proceedings, actually showed how particular language of the leadership of Israel actually steeps down into the language of military units in Gaza, right? That it's actually, if anything, there is good evidence of the opposite, of incitement, in particular terms of incitement, the stories from the Bible about killing,
Right.
what were the enemies? I can't remember
Oh, is it
the son of,
Alamech?
yes, Amalek.
Amalek.
The son of Amalek, or the seed of Amalek. And
Okay.
there is these videos of Benjamin Netanyahu using this language, and then military units in Gaza singing a song along these lines, and also finishing by saying there's no innocent civilians.
Right.
But they're using. So I would say, of course, the question of conditions of life doesn't sidestep the question of intention, but and the work that needs to be done there is distinct in proving intention. But I would say it is relatively unusual to see the language that very high-ranking leaders of Israel's political and military leadership were using, especially in the first 2 to 3 months after October the 7th. The language to me sounds as close to evidence of intent as it can be. And also the other aspect is you can also still deduce in fair intent from the pattern of destruction, right? It is possible that in cases in which the pattern of destruction is so comprehensive, it is open to the court to say that the only possible intent,
Yep.
given the extent of the destruction, is genocidal intent.
Right. And I mean, very frequently, absent a confession in criminal law, and again, this is not a criminal case, but intent has to be inferred from actions and patterns of conduct. But as we've said here, the ICJ will apply a particularly high bar before making that determination. But just on another point you've said, I mean, I think one possible outcome of the ICJ litigation, and we're a long way away from that. I mean, I think the facts grow harder and harder for Israel to defend with each passing day. But when the case was first brought, I thought, the easy path through for the court before things became as catastrophic as they've become would have been basically a finding of a state failure to prevent and punish incitement to genocide, right? Because you've got very senior people. You've even got, Haaretz newspaper saying that the finance minister in any functional state would have been expelled from the cabinet and his party by now for the openly genocidal things that he says. And if people at that level are saying things that sound pretty straightforwardly genocidal and aren't being investigated or prosecuted, that is still a breach of the Genocide Convention. That is a ground on which one could win the case. It might be a dissatisfyingly narrow ground, but it's there. And I initially thought that would be the most plausible outcome. But the longer things go on, I think the worse it looks, the worse the case is that Israel has to defend.
That's right. And I also think not only he's not investigated, but he remains part of the government. And I think that raises then questions of, is this simply a failure to prevent and to punish incitement, or is this part of proving intent? And some Israeli colleagues have tried to argue that, he's not part of the war cabinet.
Yeah.
I do though think that the fact that he's the finance minister, and given the emphasis on destruction of conditions of life, and especially of a place that we can discuss that in another episode, but that Israel has kept on a very thin line of survival for the last 17, 18 years, I think there is a very strong argument to be made that you can have a genocidal campaign within the meaning of the convention that uses economic means of destruction, right? And in which the knowledge and the actions of the military can need to be coupled by the knowledge and the actions of someone like a finance minister, someone who oversees infrastructure, in order to bring about such conditions that make the survival of the group as such impossible. So I think if you are within the conditions of life, you're looking, and that was my point also about the jurisprudential importance of what South Africa is doing. I think you're looking at a much more structural idea of how distractions of groups occur. And we know that the Genocide Convention does not prohibit the sort of behavior that we would call cultural genocide, so destruction of the group's culture without physical extermination, but through the destruction of conditions of life, it allows us to look at, the conditions that sustain life, right? And to think about violence and destruction in much more structural ways, in ways that says it's not only, as I said before, like the destruction of conditions of life does not only hinge in preventions of aid coming in, even though, of course, in the short term, that is the most acute problem, but it also hinges on destroying Gaza's food system.
Yep.
Because it makes it impossible for Palestinians to exist there, not only in terms of getting a minimum caloric intake, but to exist as Palestinians who have a particular relationship to the land and the sea. We know, for example, in Gaza, fishing is very important, or, of course, everyone in Palestine, the harvesting of olives is very important. So it renders the population dependent on aid for its immediate survival. And I would say it also impedes its existence as a group in a meaningful way. So I think what I find really interesting from a critical perspective, if I read it, not with my doctrinal glasses on, but with my more theoretical and, let's say, twale glasses on, is that, to me, especially the region submissions of South Africa are as close as you can be to a structural and twale understanding of genocide as you can be, and still be legible to an international court and an international institution, right? And that, of course, means certain limitations, including, as I said, the fact that for very specific historical reasons, the Genocide Convention does not protect groups from only cultural genocide if it is not accompanied by physical extermination of some sort.
Right. And actually, on your point of, well, there's 2 points I'd like to make, one going to the war crime of starvation, but we can come back to that. You do make an interesting point in your book, Capitalism as Civilization, particularly in relation to the Southwest Africa cases, about this issue of legibility, right? You have to sort of turn your advocacy into claims that are, as it were, encoded in law, that can then be read by judges and other lawyers. And sometimes, as in your analysis of Southwest Africa, that can take big structural claims like a system of capitalism under apartheid is a wrong, and reduce it to claims embedded in the way South Africa is administering this territory is violating individual rights. The more radical claim winds up being taken out of the picture, isn't legible to law because it couldn't grasp those structural elements. And what I hear you saying here is that actually the framework of conditions of life genocide allows much more of that structure in a way that international law can often exclude. Is that a fair summary?
That's better than I could have come up with. So it's more than fair. Yeah, absolutely. So I think there is a big difference between the two cases. which is, I think South Africa is working with a better framework. For those of you who might remember, Ethiopia and Liberia were working with Article 22 of the Covenant of the League of Nations that speaks of a, quote, sacred trust of civilization entrusted upon the mandate powers vis-a-vis the mandate territories or the mandate populations. So as you can imagine, or at least as I'm saying, this was a particularly hostile argumentative terrain. I think civilization carries as an argumentative structure a whole lot of baggage. The Genocide Convention also carries a lot of baggage. Of course, the main problem here, as I have been flagging, is that when it was being negotiated in the late 40s, European imperial powers and settler colonists were very conscious about drafting a document that would outlaw practices such as the Holocaust, but it would not outlaw practices of their own colonial projects, both saltwater colonialism and settler colonialism, for example, in the Americas, right? It's very clear if one looks back at the negotiating process that was the pull and push that led to a genocide convention that, as many have noted, was much narrower than the way that Lemkin conceptualized genocide as a harm, right? Which included very much cultural genocide. If nothing, like cultural genocide was almost at the center of his idea of what the extermination of a people as a people is, right?
Right, and for very obvious reasons, the British, the Canadians, the Australians were not going to accept that cultural genocide could be a legal concept.
Absolutely, exactly. And we know, for example, in Australia, that after immediate killings ceased of indigenous peoples, there were practices of cultural genocide, such as the taking of children from families, right, in ways that disrupted cultural continuity without necessarily killing people, right? And these practices continued, some would say continue until this day, but they definitely continued in very formalized ways in places like Canada and Australia. In Canada, I believe the last residential school closed in the 80s or the 90s, right? So you have this first impediment, right? You're dealing with a convention that has been framed in a way that excludes the violence of settler colonialism, or at least some forms of violence of settler colonialism. And I do think, I know many disagree, but I do think settler colonialism can be a very useful framework for understanding a lot of what is going on in Gaza, perhaps not everything, but a lot. So that's the first issue. And the second issue is what you alluded to, and we've been talking about, which is you have this already limited framework, and then you have years of argumentative practice, especially within international courts and tribunals, that have adopted even narrower interpretations, including what we were saying before, the idea that this has to be the only plausible interpretation in order for genocidal intent to be established, and therefore this violation at least of the convention to be found. And I think this hinges again on a very colonial mentality, which is this idea that genocide is something monstrous, which it is, but also monstrous in the sense that it is something extremely exceptional, that we need to rule out all other scenarios before we consider that genocide has occurred. And unfortunately, I don't think that this is the case. It is true that genocide with the very particular characteristics of the Holocaust, for example, is very unique. But I do think genocide is the way that settler colonies around the world, literally throughout the Americas, from the very bottom of Argentina and Chile to the top of Canada, were created. So I think
Right. Well, I mean, also, I mean, at the time of the negotiation of the Genocide Convention, the UN Secretary General said that, this is a crime as old as history. It has just not until now had a name.
yes, absolutely. So yes, this idea that I think has become part of the practice of the interpretation of the convention, which is
Right.
that we will have to rule out any and every other plausible interpretation under the sun, relies on an idea of high exceptionalism of genocide that I think historically is incorrect.
Right.
And I think law has incorporated for no reason that is in this instance grounded on textual necessity. The
Right.
Genocide Convention has textual limitations, but then I think on top of it, we have erected further limitations that are not mandated by the text. They're perhaps allowed by the text, but not mandated. And I think this is where, of course, a degree of freedom might exist within an otherwise bad structure.
So a point I wanted to sort of build off that, and then I'd like to loop back to a point I flagged on starvation. So, I mean, one of the problems that creates, both in, I think, general public international law and international criminal law, is this idea that if it's not genocide, if it's merely a war crime, that is somehow denying the victimhood and suffering of everyone. We've invested genocide with such a specialness, both such that it should be terribly rare. So when it's invoked, states can say, well, how could you possibly accuse us of genocide? But also from the victim's point of view, wait, why have you not found we were subject to a genocide? And the fact is that, very often facts can be characterized multiple ways. So we've said that the unique thing about the Genocide Convention is you must have had the special intent to destroy a group in whole or in part. But in terms of the systemic destruction of the food system in Gaza that you've outlined, that also makes out most of, well, actually all of the elements of the war crime of starvation, because starvation is about attacking objects that are indispensable to the civilian population's survival. So it's not merely about the withholding of food. It is about things like, destroying crops, agricultural land in a manner not required by military necessity. The special element in starvation being that you intended to starve civilians as a method of war. And there's some debate around the exact parameters of that, but it's also a systemic crime. And I think one of the reasons that the ICC prosecutor has gone for it in initial arrest warrants in the Israeli side is it again gets to that large systemic issue, but without requiring genocidal intent, right?
Sure, absolutely. And of course, one could have a more practical answer to that and a more systematic. The practical aspect would be the ICJ has very limited grounds of jurisdiction. Genocide Convention is one of them, unlike the ICC that, of course, has jurisdiction over a broader range of crimes. So one of the reasons South Africa has gone for it is that. The other way to think about it would be that talking also about genocide links this, the current destruction and death and suffering, to the broader question of Palestinian self-determination, right? You could make both a practical and a more principled question there, right? That what is at stake throughout historic Palestine is the survival of Palestinians as a people,
right.
And the realization of that through a right to self-determination. Again, people would have different views on that. I had a brilliant LLB student who wrote a great thesis on Tamil mass killings in Sri Lanka, especially towards the end of the war, and the struggle over naming it or not naming it as genocide. And her argument was exactly that it's a way for many Tamil people to also articulate through, in a sense that is quite paradoxical and macabre, but through their destruction as a group, their existence as a group, if that makes any sense. But yes,
no, it does. Right. Well, I mean, related to or adjacent to self-determination. Dina, off air, I think you had a question you wanted to pose me about questions of statehood.
Absolutely, yes. So my question was basically, what do you make doctrinally, jurisprudentially, politically of this trend that we have been seeing in recent weeks of many states, mostly in the global south, but also some states in the global north, recognizing Palestine as a state in response, and they make that very clear in their statements, in response to the unfolding situation in Gaza? What do you think are the implications of what we're seeing at the moment?
Right. So there are a number of things that come together here, and one is the suggestion, which I'll mention again, that recognizing Gaza as a state as an act of solidarity is not enough to add to legal recognition of it already being a state. So I'll come to that in a second. But the other thing is that, there are a lot of scholars and commentators who seem very invested in the idea that Palestine isn't really a state. Now, if you succeed on that point, then it can't really be a member of the Rome Statute of the International Criminal Court, so there can't really be cases brought against Israeli officials, and also it can't intervene, as it is attempting to do, in the South Africa-Israel case before the ICJ. And it made that application on the 3rd of June, and so quite interestingly, the ICJ is going to be put in a position where it also has to rule on whether Palestine is a state. Now, just as a simple matter of institutional reality, I cannot see a world in which the International Court of Justice or the International Criminal Court, when the issue is raised before it again, rules that Palestine is not a state when it has been recognized as such by 148 states. That's just not going to happen.
Yes.
Now, when I say that, I tend to get two arguments thrown back at me. One is the one I've just flagged. Oh, but this isn't really legal recognition. These are statements of political solidarity in favor of a future Palestinian state. And I'll come to that second.
Are there any precedents of that?
Not really.
I've never heard that before, like
No.
future recognition.
No, well, that's it. It's not a legal concept, which is why it's not a very helpful thing to raise. But the first one is just the straight up doctrinal thing, which is my thing. What about the Montevideo criteria? And I know you've got lots of views about the Montevideo criteria and their relationship to colonialism, the standard of civilization. But before I get to any of this, I'm just going to start with one of those things you hate me doing, Dina, a metaphor. So one of the problems in debating the question of Palestinian statehood is that many who want to have that debate are deeply immersed in the detail and will often start by saying something like, but obviously the collapse of the Ottoman Empire left a vacuum juris as to sovereignty in the territory that became the Palestinian mandate. And I'm just like, no, please stop. No, this is madness. When debating these scholars, it's like we're both looking at an impressionist painting, and these guys have their eyes up against individual brushstrokes, while generalists like me and you are standing on the sidelines going, but look, if you just took 3 steps back, you'll actually see a rather pleasant picture of a bunch of people having a picnic by a river. To interpret this, we have to get back from the detail far enough that you can see it in the proper frame. That being the framework of general international law. Okay, so famously, the Montevideo criteria for the existence of a state are that a state must have a defined territory, a stable population, and a government capable of administering both. And in relation to Palestine, critics may say, well, its borders are unstable and the government doesn't have control of the full territory because much of that territory is either occupied by Israel or administered by Hamas. Now, none of that is persuasive. First, to have territory, you do not have to have finalized borders. The law is crystal clear on that. And by the way, if Palestine has unstable borders, then so must Israel. Second, arguing that an entity is disqualified from statehood because its government has lost control of part of its territory due to foreign occupation or external support and funding of an insurgent group is repugnant to basic principles of international law, such as the prohibition on the use of force, both in international relations generally and in terms of altering territorial boundaries. And when Israel makes that argument in the Security Council, I'm afraid there's just also something of a clean hands point.
But also, I think beyond Israel, it would also disqualify a whole lot of states.
Oh, yeah. Well, and we can come to that.
Definitely Israel, but
Right.
I would say most of the world. I can see why if you're a global South state that became independent from colonialism with Soviet weapons, you might feel a little bit uncomfortable
Right.
hearing such an argument.
And look, so the classic example here of, oh, you became a state in part through a violation of international law, like a use of force that could constitute an act of aggression and didn't have full control of your territory. The classic one is Bangladesh, right? So in 1971, it achieves independence really through, unless you believe in humanitarian intervention and believe that was the rule in 1971, an illegal invasion by India. But in less than 10 years, there is overwhelming recognition that Bangladesh is a state, which kind of brings me on to my other point. If there's any deficiency in the claim to Palestinian statehood, there are several ways it can be remedied. The first is a myopic focus on the three Montevideo criteria omits the most important one, which is the ability, independence, political independence, and the ability to conduct relations on the international plane. And that, your ability to conduct relations on the international plane, is in part going to be a function of recognition, right? The other point is that it's very well accepted that where an entity's fulfillment of the traditional Montevideo criteria, territory, population, government, looks a bit shaky, then widespread recognition can cure those defects. I won't get into the declaratory versus constitutive theories of recognition because it's just a nightmarish rabbit hole that adds no analytical value. But how can recognition fix your claim, any problems in your claim to statehood? I think the simplest way of rationalizing that result, which is plain from the practice, is something I've heard Alex Green say, that effectively what widespread recognition does is lower the bar on fulfillment of the objective criteria. And as I've said, as we both said, there are plenty of examples of this, but in relatively recent history, many of the states that emerged from the dissolution of the former Yugoslavia had less, sometimes much less than complete governmental control of their territory when admitted to the UN. Now, on the relationship between UN membership and statehood, I'm going to tie all of this together, I promise. As we've said in a previous episode, you don't have to be a member of the United Nations to enjoy statehood, but membership of the United Nations is conclusive, irrefutable evidence that you are a state. No further debate required, no correspondence will be entered into, etc. So this brings me back to this argument about the alleged distinction between proper legal recognition and merely political or aspirational recognition. Do states recognizing Palestine really truly recognize the legal existence of a current Palestinian state, or are they just saying nice things and expressing general political solidarity for the emergence of the state in the future? Now, maybe you can find statements like that in the past, but I don't think that argument obtains any longer, because earlier this year, on 9 May, in an emergency session, the General Assembly voted 143 states in favor to admit Palestine as a full member of the United Nations. There were 9 votes against and 25 abstentions. The resolution said in the preamble and paragraph 1, and I quote, stressing its conviction that the state of Palestine is fully qualified for membership in the United Nations in accordance with Article 4 of the Charter, paragraph 1, determines that the state of Palestine is qualified for membership in the United Nations in accordance with Article 4 of the Charter of the United Nations and should therefore be admitted to membership. Now, to underscore the point, Article 4 says that to join the United Nations, you must be a state. In fact, the only reason that Palestine is not already a full member of the United Nations and therefore unequivocally recognized as a state is that the United States vetoed the membership recommendation in the Security Council. And the vote there was 12 votes for, 2 abstentions, and only the US against. At this point, there is only one sane outcome as a matter of just doctrinal legal analysis. 143 states have said legally that they believe Palestine is a state already. It is a state right now. No ifs, no buts, no nothing. They do not believe they are saying nice things or expressing an aspiration. They are declaring a present legal entitlement. Now, the only way to undercut that conclusion of mine would be to say that, oh, when explaining their votes, a number of states said that what they actually supported was a future Palestinian state. Okay, so if you can show me overwhelming evidence of very clear statements by the majority of those voting in favor, that argument might have some traction. But if all you can point to is a handful of ambiguous statements that might maybe be possible of that construction, the argument's utterly hopeless. And either way, it's going to be very hard because only 12 states bothered to formally explain their vote in the UN General Assembly. On the other hand, the United Arab Emirates, introducing the resolution on behalf of 22 states in the Arab group, could not have been clearer about what was being voted on. The UAE stressed that Palestine met the criteria for membership and invoked the legitimate right of states to full membership in the UN. So just to sum up, the only thing blocking full recognition of Palestine as a state is the US veto in the Security Council. In the Security Council, only the US and UK expressly said Palestine was not yet a state. So in 2024, so far, in total, only 10 states of 193 members of the UN have voted against that proposition, and the great majority of UN member states presently existing in the world have said they legally regard Palestine as a state right now. So no court in the world is going to rule against Palestine on statehood confronted with those facts, because, and I'll conclude my rant shortly, when there is an overwhelming consensus on the part of states, the original makers of international law, as to the correct interpretation of international law, then that is the correct interpretation, right? It's a state-based system. So the only fight left to have, in my view, at this point, is at what critical date Palestine first became a state. But we can save that for another day, as I've been banging on.
No. I think you haven't. And I think we should have a second episode on that, because I think there is a lot to be said about Palestinian statehood, but I think there is also a lot to be said about people who are making the argument that you just deconstructed, just assuming that these states and their lawyers don't have a working LLB level understanding.
Don't have the ability to read Article 4 of the UN Charter.
Yes, of Article 4, but also basic understanding of how recognition works, with all its ambiguities and problems in international law, right? I think it's fair to assume at least you have a very strong, if rebuttable presumption that other states vaguely understand what they're doing, even if you disagree with
Right.
what it is that
but there's, particularly in the Anglosphere, there's very much this tendency to kind of go, well, once the US, the UK, Australia, Canada, and Israel have said something, that's international law.
That's the international community and therefore international law. Yes.
Now,
absolutely.
we both have dinner engagements to get to. So in wrapping up these conversations, I typically ask 3 questions of my co-host. What recommendations do you have for anyone who'd like to know more about what we've discussed today? What are you working on at the moment? And what's one of your current escape routes? What are you reading or viewing or doing that's taking your mind off international law?
Okay, I didn't get to talk so much about it, but I think Noura Erakat, who is a Palestinian international lawyer and human rights attorney, has actually critique of the quest for statehood. Her book, Justice for Some, International Law in Palestine, is remarkable. It's a remarkable piece of work, and I would love to get the opportunity to talk more about it, but if we don't, I think the readers will benefit from that. I am working on things that are and aren't related to what we talked about. As you know, I think about it a lot these days about the political economy of war. So who makes the bombs that drop in Gaza, and how international law has become so useless in holding them to account. And my escape route, so as you know, I watch so much TV. It is truly shocking how much TV I watch. I'm currently watching a Korean drama called Stranger, about a strange but very, morally upright Korean prosecutor fighting corruption in Seoul.
Fantastic. I love a good K-drama. I don't get to watch quite as many as I'd like. I think the last one I got really engaged with was Kingdom, the zombie K-drama set in kind of feudal Korea. Terrific. Well, I think that pretty much brings us to the end of the episode.
Thank you for the invitation.
Oh, Dina, you're part of the core team. You're going to be here regularly. Thank you so much for accepting the invitation to be part of that core team. So thank you, everyone. Thank you for your patience. Thank you for sticking with us. And we will be back again in a week. Bye-bye.
Bye, everyone.